In this class we're going to look at the law of contract. Now this is an extremely important topic in commercial life. It's an agreement between two parties to do something, and it takes a legal format so that if the parties do not honour their side of the agreement, then some redress can be claimed by the other party, some compensation, if you like, can be claimed by the other party to the agreement. Now, contracts are very widely used in business, and it's important for us to understand what's meant by them. So we'll start by looking at a definition of a contract, which is simply a contract is a legally binding agreement. It's a legally binding agreement. That is the nature of a contract. And for a contract to be valid, it must have several requirements met. These are, there must be an offer. In other words, one of the parties to the agreement must offer to do something, and the other party to the agreement must accept. So there must be offer and acceptance. They must be freely undertaken, no duress, no force, no bribery, nothing wrong, just openly and freely an offer and an acceptance. And there must also be an intention between them to create a legal relationship. So they must intend for a contract to come into existence. And there must also be what's known as consideration. We'll deal with consideration properly later, but for the moment, consideration may be viewed as some, if you like, advanced agreement, some agreement in advance of the contract, that if the contract is not fulfilled, then both parties stand to lose something. So there must be some consideration, must be some recognition that there is a contract, and that if both parties do not try to fulfill the terms of the contract, then this consideration may be lost. We'll talk about it later. And when all of those are met, we have a contract. Now, we can spend a long time dealing with each of these terms, and in the coming classes we will spend quite a bit of time looking at them. It's a really big topic. It comes under civil law. It's not criminal law, it's civil law. It's an agreement between two people. It's a voluntary agreement. It has those terms in the agreement: offer, acceptance, intention, consideration. And we need to go across this in sufficient detail to give us an understanding of the legal relationships that seem to bind businesses together. So let's look at the requirements for a valid contract. So one of the parties must make an offer to the other party. Without that, nothing will happen. There will be no contract. There will be no agreement between them. And the other party must accept the offer. So it's not done under duress. There's no force, or there's no trickery involved. This is an open, honest agreement. One party offers to do something, the other party accepts the offer. The circumstances of the offer and acceptance must indicate that the parties intended to enter into a legal relationship. So looking at the way they went about the offer and the acceptance, it must be clear that they intended to have a legal relationship. And the two parties must give consideration, some sort of benefit to the other. So these are the requirements for a valid contract. Without these, the contract will not be valid. It will not be upheld in court, should there be an issue about the contract later. Now the conditions of a contract, well, the parties involved in the contract are bound to honour its terms. There was intention for them to do so, so they should do so. And where a party does not carry out the terms of a contract, he or she is in breach of contract. So if the two agree on the terms of the contract and two enter into a contract, and one party does not carry out his or her side of the contract, then there is a breach of contract. The contract is broken. And the consequences of such a breach will allow the other party to perhaps legal remedies. If one party breaches the contract, the other party can go to court and claim compensation for the breach of contract. So those are the conditions of a contract. Now this class is short because we just wanted to get across the essential ideas of a contract. It will get a lot more difficult as we get into it, and it'll be more detailed. But for the moment, that's all we need to do about the conditions of a contract and the nature of a contract and the terms of a contract. So let's leave it at that and say thank you for watching.